perhaps we'll make a start. Big welcome to you all. This is the first in a series of property webinars that we're running. So they're going to be once a month until July. And this one is about breaches in contracts for sale. So I'd be interested to know other people's experiences, but it seems to me that the pandemic is meaning that people are evaluating the wisdom of transactions that they entered into before we all went into the first lockdown. Things that seemed so right in 2019 might not seem such a good idea now. And the focus on our talks today is on decisions which are made, difficult decisions which are made under pressure, which we know these cases involve. We're very, very keen to have lots of questions and contributions, thoughts. We know there's an awful lot of expertise out there in the audience. Please do share it. There are going to be a couple of polls, so get ready with your fingers on the voting buttons, as it were, when those come up. And also, please do put questions on the Q&A function. So if you go down to the bottom of your screen, if you put your mouse down to the bottom of your screen, Q&A, and you can pepper us with as many questions as you like down there. You can feel free to use the chat function, but as regards questions or comments, it's easier for us if you can put them on the Q&A rather than in the chat function. But please do feel free to talk to one another as we go along. And if you're feeling shy, you can put a question down anonymously.
Easy for you to say.
Easy for you to say. That bottle of wine before breakfast obviously didn't go too well. Right, on that note, I'm going to hand over now to Tiffany and Simon, who are going to chat for a bit about specific performance.
Yeah, thanks, Joanne. So, yeah, in these COVID times, Simon and I thought we would explore some of the aspects of specific performance that have perhaps not received too much attention in recent years, but which we think people may start to see more of in the coming months. And the first aspect is insolvency and how the remedy of specific performance may be affected if your counterparty becomes insolvent, whether that's a vendor or purchaser in the context of contracts for sale, or landlord or tenant in the context of leases or agreements for lease. And I'm going to deal with that. And the second aspect, which is related to the first, is what happens if the contract as drafted is not possible to perform in its entirety? What can the claimant ask the court to do in those circumstances? So Simon is going to deal with that. And along the way, we'll take in some points on strategy. And then if we've got time, we will take any questions that have come in for us. So let's have a little poll first to get us going. We're interested to know whether claims for specific performance have been coming across your desk more regularly in recent times or not. So our poll is asking, since the start of the COVID pandemic, have you seen a change in the number of specific performance claims? So the options are yes, I've seen an uptick, no, there's been a decrease, or it's stayed about the same. So cast your vote now, and we'll see whether our clients are generally more likely to be seeking to enforce contracts now, whether they're happier to walk away and rescind and possibly resell if it's a contract for sale of land, or has there been no change at all? Trying to predict what the answer might be. Oh, stayed about the same is most people's experience. Some have had an uptick, but it hasn't really gone down. Well, that's interesting. So, well, hopefully what we've got to say will give you some food for thought next time one of these cases comes across your desk. I'm going to kick off with a few thoughts on insolvent defendants. So just to remind ourselves of the nature of specific performance as a remedy. Of course, as I know, all of you know, it's discretionary and the claimant will have to show that damages are not an adequate remedy. So in general, specific performance of contracts relating to land is granted as a matter of course, whether you're the vendor or the purchaser, because that is the way we do things in England and has been for a long time. And real property is regarded as unique, and damages are said not to be adequate. So the question we want to explore is whether the insolvency of the defendant affects that general position. And so the first point to mention is that insolvency of a defendant is not in and of itself an argument against granting specific performance if the contract is otherwise specifically enforceable. However beneficial to the creditors of the defendant it might be if the remedy is refused. So the defendant's not generally going to be able to argue that its insolvency should be a ground for refusing specific performance. on the basis that specific performance would undermine the statutory scheme for distribution of assets on the insolvency of a company. But on the other hand, insolvency is by no means irrelevant to the court's deliberations. I'm going to make 3 points about that, and we're going to explore 2 of them in a bit more detail. So the first point to remember is permission from the court's going to be required to commence proceedings against your insolvent defendant. Don't forget that, and it could be refused if the case for relief is regarded as being weak. And that leads into the second point, actually, which is that relief could be refused as being pointless. So the principle is equity does nothing in vain, and the court will refuse to order specific performance if doing so would be a waste of time and money. So you need to make sure that the relief relates to something that an insolvent defendant can do. And also you should look around to find some good reason for making the claim, such as preserving a claim against a third party, which I'll come on to in a minute. And the third point to remember is that there's a general power for liquidators or trustees in bankruptcy to disclaim onerous obligations. This doesn't apply to receivership, but specific performance is going to be unlikely in cases of receivership if it's going to act unfairly, because it will make the receivers personally liable under the contract without their consent. So let's just focus on those last 2 points and look at some examples. Although equity is not going to act in vain by decreeing specific performance against your penniless defendants, there's no bar to the apparently pointless grant of specific performance if some purpose is going to be served by it. So, for example, the court's not going to grant specific performance of an agreement for lease if it looks like the insolvent party is not going to be able to perform their covenants, but the court might enforce a surety's obligation to take over a lease that's been disclaimed on the insolvency of the tenant. So there's a case called RVB Investments in Bibby from 2013. And in that case, the landlord was claiming against the defendant surety. So the landlord wanted the surety to execute a new lease for the residue of the term. So landlord had let premises to the tenant, tenant became insolvent, landlord liquidator disclaimed the lease. Disclaimer didn't discharge the surety of its obligations, so it was obliged to take a new lease for the residue of the term. But even where it's the insolvent tenant who's the party to the action, it's the party to the agreement for lease, the landlord wants to compel the insolvent tenant to enter into the lease. The court might require the tenant itself to execute a lease in order to perform the contract, because doing so will trigger the surety's obligation to pay rent. So there's a case called AMEC Properties from 1992. And the Court of Appeal said, well, there's no objection to compelling this insolvent lessee to execute the lease because there was said to be a good reason for making the order, because the execution of the lease would activate a third-party guarantee of the rent. And so the claimant wanted specific performance to require the tenant, who was D1, to take the lease so that the liability of D2 as its guarantor would be triggered. And the Court of Appeal said, well, the fact that D1 is insolvent isn't a basis for denying relief. And that was the case where it was argued that specific performance would undermine the statutory scheme for distribution of assets on insolvency, and it would cause hardship to the creditors. But the Court of Appeal said no, and it rejected that argument.
Yes, and Tiffany, also, of course, it's the case, isn't it, that the court has jurisdiction to award specific performance together with compensation? Yes,
exactly. So if you've got a defendant who's a developer stroke vendor, and they've promised to build housing on some land and then convey the land to the claimant purchaser, but the developer goes insolvent before finishing the building or even before starting the building, the claimant may be able to obtain specific performance of that contract to convey the land together with a reduction or an abatement in the purchase price to reflect the fact that it's undeveloped. So there's a case called Manchester and District Housing Association and Fernley Construction from 2000. And the construction company, the developer, went into liquidation before the building works were complete. The Housing Association wanted to get specific performance of the agreement to convey the land. And the court said, well, although the time hasn't yet arrived for this developer to honour its obligation to convey, because that only arose on completion of the building works, which was an impossibility by that time, nevertheless, the developer couldn't rely on its own breach in seeking to avoid the obligation to convey. So, and the developer also said, well, this contract is an entire contract. in other words, the obligations to build and to convey were so closely linked that one couldn't be enforced without the other. And the courts rejected that argument too, and said that fairness and justice dictated that the housing association should have the remedy in this case, because it could be easily enforced and it wouldn't cause injustice to the developer. So the court ordered specific performance of the contract at the abated price. So that's the first of the 2 points we were focusing on, i.e. equity doesn't act in vain, but you can sometimes find a good reason why the court would order the contract to be completed. And just looking at the second point, the power to disclaim onerous obligations. So that could be exercised on liquidation to leave the claimant having to prove for damages. But in this context, you've got to bear in mind that there'll be a difference between your contracts to sell real property and other specifically enforceable obligations, including even agreements to take property, to take a lease, or to carry out work. So when you're dealing with a contract to sell land, the purchaser has an equitable interest for the time the parties enter into the contract. So that can't be divested by the liquidator exercising the power to disclaim. So where your defendant is the vendor under the contract for sale and becomes insolvent, the liquidator is not going to be able to avoid specific performance by disclaiming the contract. But even if there's no disclaimer, then just looking back at what we've just been discussing, the court might refuse relief in any event if it would be pointless to order the impecunious defendant to do something it can't do, such as carrying out work, for example.
So is it possible maybe to look at this from another perspective, Tiffany? I mean, if specific performance would not normally otherwise be granted, does the fact that the defendant is insolvent and is not going to be able to satisfy damages affect the question at all as to whether damages would be an adequate remedy?
Right, so if defendant's insolvent, not going to be able to satisfy the award for damages, does that affect the question? The answer is no, that's generally considered to be irrelevant, because insolvency doesn't make damages an inadequate remedy or otherwise justify ordering specific performance. Because if you look at it this way, the claimant is a party to the contract. It's elected not to take any security for performance of the defendant's obligations. So there's no reason to be manipulating the law of specific performance to give the claimant that assurance that it never bargained for. So if you've got a contract that doesn't normally lead to specific performance, it normally only sounds in damages, the court won't award specific performance of that just because one of the parties has gone insolvent. Okay, so I'm just going to sum up on the subject of insolvency. Specific performance would be awarded against the vendor under a contract for sale of land. And so one effect of that is to give your claimant vendor, your claimant purchaser, an effective preference in the defendant's insolvency. And that's because the existence of this specifically enforceable obligation is regarded as constituting the vendor as trustee. And there's clear authority that that trust can be enforced against the liquidator or administrator. So it's over to you, Simon, I think. So you're considering what happens if a contract isn't possible to perform in its entirety. Does that curtail the remedy of specific performance? And that is somewhat indirectly related to what we've just been discussing, isn't it? About insolvency. And it could be quite an important issue in the current climate, I would have thought. You've got your government regulations forbidding certain trading or activities. There could be a whole host of obligations which parties might say they can't perform. So there may be issues of impecuniosity if you're falling short of insolvency, but you just don't have the money to complete. And the counterparty may say, well, I haven't got the financial circumstances now. What is the innocent party then lumped with? Accepting the contract might fall away, or being confined to damages for non-performance? What do you think?
Yes, these are all issues which may well arise as a result of the circumstances over the last year. And I think the first thing, and the most important thing that a potential claimant should always ask him or herself is this: is the contract really impossible to perform? Because if a contractual obligation is impossible to perform, then specific performance will not be ordered of that obligation, because equity, as you said, Tiffany, won't act in vain.
Yeah.
But actually, it's relatively rare to encounter in practice an obligation which is completely impossible to perform. So to take the case of a party who says that his or her financial circumstances are so changed for the worse that they can't complete, well, does lack of funds equal impossibility? Well, in principle, it may do so, but that argument rarely washes in court. And I think cases which emerged following the credit crunch in 2008 could provide a helpful guide, I think, as to how a court might approach a similar argument, which might be advanced by a defendant resisting a claim for specific performance in the current circumstances. So there's a case called Matila Limited and Lish Properties from 2010, and in that case, the claimants, who were developers, sought specific performance of a number of contracts for the grant of leaseholds over residential apartments and commercial units. And in relation to the residential apartments, there'd been a delay to completion, to their completion by the claimant developers, although the judge found that that wasn't the fault of the claimants. But it was argued by the defendants defending the specific performance claim for completion that as a result of the delay and a diminution in the market value during that period, the apartments had gone down by half, they had been unable to obtain the funding required to complete the contracts. And the judge said, well, specific performance might be refused where lack of financial means renders performance impossible, but importantly, a very heavy burden lies on the defendant to show impecuniosity. And that hadn't been satisfied here. The judge ordered specific performance, and he said there was a real difference between concluding, as he did, that the defendants saw no way of completing without obtaining funding on the one hand, and concluding, as he did not, that at the date of trial, the combined finances of the defendants, coupled with their access to third-party funds on whatever terms, was such that it was simply impossible for them to complete the contract for sale. So although the fall in the property values in the credit crunch might have rendered the defendants financially unable to perform, it was incumbent upon defendants to give the fullest possible disclosure of their financial position, which they hadn't. I think the headline point there is there is a real difference between difficulty in performing an onerous financial obligation, which won't be a bar to specific performance, and actual impossibility properly evidenced, which will preclude it.
Right. Well, you can see in a specific instance of this counterparty's alleged impecuniosity, you can understand why the court would be reluctant to find that that's a reason for not granting relief. It's very self-serving, isn't it, for a defendant to say that I haven't got the assets to complete, just as part of an attempt to evade specific performance. So it may now be a bad bargain, but that's just tough. But what about a less clear-cut case? What if defendant's performance is rendered impossible because of some other feature, perhaps not the fault of the defendant?
So in that case, where you've got sort of some other feature which might render performance impossible, you can still get specific performance, provided the contractual obligation can still be substantially, if not wholly, performed. In cases of what's been described as sort of trivial breaches, a court may be willing to fashion an order on slightly different terms from those in the agreement, just in order to mitigate the sort of the impact of that impossibility. So take as an example, I think, a vendor who can't give title to all of the land to be conveyed because, say, for example, there's an error or an uncertainty in the attached plans. The cases suggest that as long as the defect is trivial, you may still be able to get specific performance. So there was a case of called Fraser's Islington and the Hanover Trustee Company, also from 2010, where Mr. Justice Briggs gave, as an example, a seller who had contracted to convey 3,000 acres of land, but couldn't give title to 1 acre at the edge of it. Now, although obviously strict compliance with the obligation to transfer into warrant title was therefore impossible, the judge said that the court would still be minded to grant specific performance, but with an abatement of the price to reflect that 1 acre for which title couldn't be given. And it's been noted in a recent case of Dreams Limited and Pavilion Property Trustees from 2020 that the same would also likely be the case if the seller couldn't deliver vacant possession of that 1 acre. So in cases of so-called trivial breaches, specific performance may still be ordered, albeit on all terms, to address the extent that impossibility.
Right. Yes, but again, I mean, that's quite a specific example of a trivial breach, isn't it? What if the breach isn't trivial?
Yeah.
What if, say, your counterparty is obliged as a fundamental part of the transaction to procure, say, a performance bond from a third party and doesn't do that? Is specific performance available in that situation, or is it precluded? The third party may not be a party to the litigation, of course, so it could not possibly be compellable.
So again, in this sort of scenario where the defaulting party's actions are dependent upon the actions or agreement with a third party, it's important to consider whether it's truly impossible for the defendant to satisfy that obligation or not. And it seems to me there's sort of two principal issues to consider in that scenario. The first is the relationship between the defendant and the third party. And the second is whether the obligation can properly be described as impossible or merely uncertain. So if we take each in turn, where you have a situation where the third party is essentially a creature of the defendant, so the relationship is a very close one, then that won't be a bar to ordering specific performance. And that was the case in a case of Jones and Lippman, where the vendor had, pending completion of a transfer of land, conveyed the land away to his creature company. And the court held that was no bar to specific performance. And that case was approved actually by Lord Sumption in the Press and Petrodol Supreme Court decision. But obviously that's, again, quite a specific situation where the defendant essentially controls the third party. What if they don't? Well, this is where the second issue comes in. It's important to consider whether the entry by the defendant into, say, an agreement with a third party, for example, a performance bond, or the obtaining of such a performance bond, is actually impossible or merely uncertain. Now, obviously, if it's actually impossible, then this will likely, although not necessarily, I'll come on to that, likely to be a bar to specific performance. But if it's merely uncertain whether the defendant can or cannot enter into an agreement, then the court may be willing to make an order that the defendant take all reasonable steps or best endeavours to procure the performance of the contractual obligation. And that was the case in Liberty Mercian and Cuddy Civil from 2014. And in that case, the court had ruled that the claimant and the defendant had been parties to a development contract, and notwithstanding that contract, there were still some subsisting contractual obligations on the defendant to procure the provision of performance bonds and collateral warranties. And the judge had to consider whether to order specific performance of that. And he held he was inclined to do so, but obviously was concerned not to order that if performance of the obligation might prove impossible. So he adopted a sort of staged process where the defendant was ordered to use its best endeavours to obtain both the performance bond and the warranties within a specified period.
Right, yes. Well, you can see, and that's a nice little sort of third route through, isn't it? Fair enough, you could have a best endeavours order that could be made. But what if your defendant still fails to procure the agreement of the third party? Is that an end of the claim for specific performance?
Well, not necessarily, as the Liberty case actually demonstrates. The court might still be able to fashion an order that requires the defendant to perform an obligation, but which, while different from the contractually agreed obligation, nevertheless provides the claimant with equivalent rights. So in Liberty, the case came back and the defendant said, well, I haven't been able to get a performance bond, notwithstanding my best endeavours. And so the issue then arose whether the court might, as an alternative, order that the defendant pay an equivalent sum of money into court as essentially substituted performance. Right. And the court held it could order that. It relied on some fairly ancient authorities, but found that where an obligation was agreed between parties and it proved impossible to perform when the time came for performance, then if that obligation was a matter for which specific performance would have been ordered, the court would seek to order performance so as to provide the party with equivalent rights by substituting the original performance with other performances, and in that case, the payment into court. So provided there could be a performance which provided the claimant with equivalent rights to those under the performance bond, then there could in principle be an order for specific performance, but by way of a sort of substituted performance. Right. And in this case, the court held there was no reason why they shouldn't order payment into court. I think the headline point of all of this is, before you write off specific performance as being unavailable for impossibility, do ask yourself whether the obligation really is impossible to form. Difficulty doesn't equate to impossibility. Uncertainty doesn't equate to impossibility. Dependency on third-party actions doesn't necessarily mean impossibility of performance. And even if strict compliance with a contractual obligation is impossible, you may still be able to get substituted performance. Equitable remedies don't necessarily fall at the first hurdle. Think creatively. and you may be able to compel the defaulting defendant to perform, if not exactly what was agreed, then something broadly equivalent.
Yeah. Yeah, so we've had a question which is on this particular issue from Karen Mason, who says the cladding issue, which we all know a lot more about, is now leading a lot of lenders to refuse lending on properties where cladding is an issue. Would that be regarded as an issue which would now mean that specific performance would not be granted? I suppose that comes back to your Matila and Lisheen case with those contractors, those people who had contracted to purchase interest in land where they couldn't obtain funding.
Yeah.
But the judge there thought that he would order specific performance, even though there wasn't an immediately obvious way of completing without obtaining funding. But that seemed to be a question of the evidence that could be produced by the defendants as to whether they were financially able to perform by some other route. So perhaps there wasn't enough evidence in that case that it really was impossible to perform. It was only just quite a lot more difficult.
Yes, and I think in the case of the cladding issue, I can imagine judges would be quite sympathetic to purchasers who are unable to complete because they couldn't get funding because lenders were simply refusing. And there have been widespread, obviously, there's been widespread publicity about the difficulties in getting the correct forms and so forth. And I would have thought in that situation, properly evidenced, if defendants had said, we've tried, we've looked at all of these lenders, they've all said no, and these other ones we haven't approached have got similar restrictions. We just can't fund it. I think you might have a bit more sympathy from a judge if you were trying to defend a claim for specific performance in those circumstances. I think a judge might be more amenable.
Yeah, and so someone's just asked what was the name of that case, and it's Matila, Matila Limited, and Lisheen, Lisheen, Lisheen Properties Limited. It's 2010 EWHC 1832. Okay, so I think we're at the end of our time, just bang on 10 o'clock. So we'll hand over to Joanne and Jonathan now, and we'll turn ourselves off, but we'll still be listening.
we appear as if by magic. So yes, Jonathan and I are going to have a bit of a chat about the opposite of specific performance, which is termination of contracts for sale. So what happens if your client comes to see you, the time for completion hasn't yet arisen, they're the buyer or seller under a contract for sale, they've had enough, something's gone badly wrong, and they want to get out, but you want to ensure on their behalf that the maximum damages claim is preserved. So we've got a little bit of a poll for you. Let's take the temperature, if we could ask for that to go up. Your client wants to get out of a property contract. The other side have committed a breach of contract. Which is the less risky option by way of termination? Alleging a repudiatory breach and terminating, or relying upon an express termination right in the contract? So let us have your views on that.
I'm waiting for the Eurovision results to come in, isn't
it? Don't tell us it's 0 point. 93% think relying on an express termination right in the contract. Interesting. Thank you very much for that. So Jonathan, what are the issues?
Yes, I mean, the main issue that we're going to touch on today is preserving a part of a damages claim that relates to loss of bargain damages. And so I think, just so everybody knows what we mean by that, we're talking about the full amount of damages that would put you or your client in the financial position they would have been in had the entire contract been performed. So just to give an example that we'll come back to, if you imagine there's an agreement to purchase for 10 million with price payable, say in £1 million instalments, and the market value drops to, say, 7 million, the loss of bargain damages, if you terminate, would be that 3 million difference between the 10 million purchase price and the 7 million that it's now worth, if you're the seller, because you would have got 10 million and you're now stuck with an asset that's only 7. Now, common law, termination at common law, you can only get those loss of bargain damages if the breach is one which would entitle the innocent party, so your client here, to determine or terminate the contract. And the problem that we want to explore a little bit today is what happens if you jump in and use that contractual termination clause or method, and how that impacts on that claim. And I think it's fair to say this is quite complex and in places counterintuitive territory. So what are some of the problems that arise, Joanne?
Yeah, so if you've got an express contractual right to terminate, and I think 93% of you thought that would be the least risky way of going ahead, there are various ways it can impact on a claim for loss of bargain damages. So you can have a situation in which essentially the contract provides a complete code for terminating the contract and essentially ousts the common law right to terminate for a repudiatory breach and claim loss of bargain damages. Now, I have to say they're fairly rare because the courts will take a lot of persuading that parties have given up their common law rights, and most contracts will contain an express preservation, this is without prejudice to other rights and remedies. So it's fairly rare, but something to be aware of. The more common problem is that there may be a conflict or a difference between the circumstances in which you can terminate under the contractual provision and the circumstances in which you can terminate at common law. And in those circumstances, there's a real need for careful thought, because what might seem to be an easy option, for example, using a contractual termination right that doesn't involve you having to prove a breach, that might actually cause you to lose your claim for damages. And in all cases, there's definite need for care in drafting a notice of termination, because even if both rights exist, even if your client has the right to terminate under the contract and also the right to accept a repudiatory breach, you may lose those important loss of bargain damages if you go down the wrong route. And there's a good example of that in the case of Phones for You and EE. Phones for You went into administration and ceased trading, and the cessation of trading was a repudiatory breach, or at least was assumed to be a repudiatory breach for the purpose of the summary judgment application. And EE terminated their contract using a clause which allowed it to determine the contract if Phones for You went into administration. And in its notice, it said that, and it also reserved all other rights and remedies. And what the court held was that EE had chosen not to treat the contract as being discharged by breach, but on the grounds of Phones for You's administration. And that didn't involve a breach. And therefore, they were entitled to terminate the contract, but they weren't accepting a repudiatory breach, even though it existed, and they weren't entitled to loss of bargain damages. So really significant consequences from the way in which that notice was drafted.
Yes, I think what's interesting about that is that the moment of your election or your choice is at the time of service of notice. It's not the sort of later on election between remedies, so you can sort of, try to push the decision off, if you like. It really is the decision that's made at the time of the notice. So just to remind people what we're looking for when we say a repudiatory breach that would leave this damages claim open. The first and easy option is if you have a breach of a clause which is a condition, so not a condition subsequent or a condition precedent, a condition rather than a warranty or an intermediate term. And that's something that is either expressly clearly so indicated in the contract, or failing that, if you're looking at the contract as a whole, is this an obligation where the terms of the contract in its commercial context are such that it's sufficiently important that any failure to perform, however minor, would give the innocent party the right to terminate. If you don't clear that threshold, the next option would be a sufficiently serious breach of an innominate clause, and I think this is probably the more likely ground on which we'd be looking at, and the test there is one I'm sure we all know. It's whether the consequences of the breach are so serious as to deprive the innocent party of substantially the whole benefit. It's just worth flagging that substantially whole benefit is quite a high threshold. You probably know in this context there's a case called Telford Homes from 2013 where a construction company delayed building a mixed-use block quite seriously in breach of an agreement for lease. The breach wasn't sufficiently serious to deprive the party of the whole benefit. There's also another route, which is if the party indicates by words or conduct that it doesn't intend to perform the whole contract, it's renunciated the contract, and that would also give you the opportunity to terminate for breach. And it's worth flagging one of the early dangers here is that if you purport to accept a repudiatory breach, where it isn't in fact repudiatory breach, you might yourself, on behalf of your client, be putting them in a position where they are in repudiatory breach of contract because they have set out their intention no longer to perform. So you're at risk if you, in terms of identifying the relevant threshold of seriousness, and you're also at risk in that it may give the other side the opportunity to walk away. And I think that's probably why we all think of contractual, or most of us think of contractual termination clauses as safer. But where are the dangers there, Joanne?
Well, they come in a whole variety of shapes and sizes, don't they? Contractual termination rights. Some of them don't. Some of them allow for the contract to be terminated without any kind of breach being established. So, for example, we saw in the Phones for You case, an event of insolvency is not a breach of contract, but it is commonly inserted as a ground for terminating a contract. Another common occurrence might be something not being done by a long stop date. So there's often an absolute right to terminate a contract if a particular date has come and gone and something hasn't happened. And they are the easiest kind of clauses to operate because they're nice bright lines. You know whether or not the 1st of January 2021 has passed. You know whether or not a company has gone into administration. But they are the most problematic in terms of keeping a loss of bargain damages claim alive because they don't involve any kind of breach at all. And so there is a deliberate choice to go down a non-breach route if you're choosing to rely upon those. You can have clauses that do have a breach, but where the breach isn't necessarily repudiatory. So, for example, it's quite common to have a clause which allows parties to terminate a contract for a material breach. Well, a breach of contract might be sufficiently non-trivial to be material without being so serious as to be repudiatory. Or you might have certain categories of breaches which allow for termination and others which don't. And the thing to bear in mind with those is that those clauses allow for a wider number of circumstances in which contractual termination can take place, not all of which will also be a repudiatory breach and will give rise to a claim for loss of bargain damages. So there's a sort of overlap there between the common law and the contractual rights. And then there are clauses where there are procedural steps that have to be taken as part of the contractual termination right. So, for example, you might have to give a period of notice, or you might have to give the other party an opportunity to remedy their breach. Give them a reasonable time or give them a specific amount of time to remedy their breach. And the difficulty with those kind of clauses is that the carrying out of the procedural steps, the giving of the notice under the contractual termination right, might well affirm the contract and thereby deprive your client of the opportunity to say, that's it, I'm out for a repudiatory breach. And there's quite a good example of that in a case called Shell, Egypt and Dana Gas. There was a right to terminate the contract if a particular event hadn't occurred by a particular date on giving 30 days notice. And that notice was given and nothing else had to be done, just simply in 30 days time, this contract is going to come to an end. but it was held that because that route had been taken and notice had been given, the opportunity for claiming loss of bargain damages had been lost. So utilising the clause was inconsistent with treating the contract as immediately at an end, which is what you need to do if you're going to accept a repudiatory breach. Jonathan, any particular examples you can think of?
Yes, I mean, going back to the example I used, the loss of bargain damages, if we have a contract of sale for 10 million off plan, so construction needs to happen, with part payment of the purchase price by instalments, and for ease of exposition, let's say they're £1 million instalments, and the buyer fails to pay the second instalment. So just to flag, we're not dealing here with a failure to complete. We're very early in the process. We're nowhere near being ready to complete. And notices to complete and those kind of things have their own code in the standard terms, which I'm sure everybody will be familiar with. Imagine our contract has the termination for material breach clause that you were talking about earlier, Joanne. I think the first question is probably, does that exclude the common law rights at all? The answer to that is almost certainly not, for the reasons really Joanne gave. And also material breach terms, they add to and expand the territory where you can terminate. They don't try to cut it down. So it's not really a case of giving away your contractual rights there. I suppose the next question is the failure to pay a material breach? To my mind, obviously, yes, it's a substantial obligation. It's a reasonably large amount of money, and it has an impact on the payment structure of the contract. But is it a repudiatory breach? Well, not necessarily. First of all, does the contract identify it as a payment as a condition? Unlikely the word condition would be used. It may be, for instance, in stipulations for time, that the hallowed phrase "time is of the essence" would identify that it was intended to be a condition. But if that's not there, then it seems to me you probably are in difficulty, because there is wording that's used to make time of the essence, and it's not here. So you can't use the condition. There may well have been no renunciation. The other party aren't saying we're walking away. They're just saying we can't find the money at the moment, but we'd love to carry on. So is this a sufficiently serious breach of an intermediate term that would give rise to a repudiatory breach? Well, that seems quite difficult. It's 10% of the overall performance, 1 million out of 10. It's not that. It's quite hard to see how that could be substantially the whole benefit of the contract. On the contrary, so how do you reach that high threshold I was talking about earlier? And I've seen we've had a couple of questions come in about putting notices in the alternative, and we'll come on to that. But I think the risks at this stage that you need to be thinking about is working out what breach you want to go with, and whether or not you want to go down the common law route, either instead of or as well as the contractual one. So that's material breach. I don't know what you think, Joanne, about the notice provisions.
Yeah, absolutely. It's interesting. We can, as you say, we've had a number of questions, and we can come back to those. I was going to think of an example the other way around. If you were acting for a buyer who wanted out. Now, in fairness, loss of bargain damages are often less useful to a buyer, because if the buyer's paying market value for the property, then there's no difference between the market value and the price, and there's no real benefit in loss of bargain damages. But it may be that your buyer client has made what it thinks to be a particularly good deal, and it thinks there's a real loss there. So you might have, for example, an obligation on the seller to do substantial works, and they've been badly delayed. And your buyer client might say, I've had enough, I'm out, but I still want to retain the ability to get these loss of bargain damages. Let's think about a contract which has, a contractual termination clause permitting termination if a breach has not been remedied within, say, 21 days of a notice being given. like in your example, Jonathan, first question would be, is that a comprehensive code, which means that there isn't a common law right at all? Probably not, and particularly not if other rights and remedies have been preserved in the contract. Is that breach repudiatory? Is mere delay on the part of the seller in carrying out the works repudiatory? Well, as you said earlier in relation to the Telford case, it's often quite difficult to establish that it is, and it's often a very difficult judgment to make, and it's one of these, you know, speedy decisions that we have to make on behalf of our clients to advise them properly, and it's really difficult because it's a multifactorial decision where lots of different things go into it. So serious delay might be repudiatory if it's really, really serious, if it's really gone on for a long time, and if in effect the seller isn't really complying with the contract at all. But delay by itself might not be. Then the question is, if you give this notice saying, seller, you must remedy your breach within 21 days, do you affirm the contract? Well, I think you probably do, don't you? You've relied on the contract. You haven't treated it as being at an end, and that's going to prevent you relying upon the breaches that have taken place so far. And then the question is, well, if the seller doesn't remedy the breach, can you still rely upon the doctrine of repudiatory breach, common law rights at that point? Well, what you'd have to show is that the seller's actions since the notice was served are themselves repudiatory. And in my judgment, it sort of makes quite a complex multifactorial decision even worse. It's even more complicated by having served that notice. So it's really a very, very difficult decision there as to whether you've got any common law rights that survive. So Jonathan, advice to property litigators thinking about drafting notices?
Yes. Is it worth? Should we start with the questions that we've had about whether or not you can just solve this by putting the notice in the alternative? It's attractive, and I think if it can be done, it is the best way. But the problem is that because it is this election type idea, if you just simply say we rely on one and or the other and or the third, you start getting into difficulties. I mean, if we take your example, Joanne, for instance, where the right to terminate is a sort of notice with a period of cure, for the reasons you say, that is affirming the contract, because you're saying the contract's ongoing, I'm relying on the contractual mechanism, let's give people a bit of time to sort it out, and then if not, it'll terminate under the contract. So how analytically can you do that on the one hand while saying, well, we're treating it as over? Now, in the Shell case you mentioned, the judge said the way round to do it is to serve a notice accepting a repudiatory breach, and then saying, you know, as people have raised in the questions, in the alternative, we exercise, or if we're wrong, we exercise our contractual right to terminate. I don't know what you think, John. I have to say, the notices I review have not always been drafted with that clarity of analysis as to which is the primary termination right, because the decisions are being made at speed. Everybody's just throwing everything at it. And I think the problem is if you just do alternatives in a very simple way, I think you start to get into issues about, you know, which one have you picked?
Yeah, I mean, I think that's a good example, because requiring your counterparty to remedy a breach is undoubtedly relying upon the contract. So there is a clear conflict between that and treating the contract as being at an end. So the right to require a remedy can only exist if you're wrong about the repudiatory breach, it seems to me. So it does have to be the way, in that example, it has to be the way round that you've explained, Jonathan. You have to say, our primary case is, this contract is at an end, we are accepting your repudiatory breach, that's it. But if we're wrong about that, and in fact there hasn't been a repudiatory breach, then we're requiring you to remedy it. And so that's probably the sort of conceptual way to do the notice. What the difficulty is then, what do you do after the notice? Yeah. You've got to, in a sense, you've got to pin your colours to the mast. I mean, either you're going to abandon the claim of acceptance of a repudiatory breach and press for remedy or not, and it makes it difficult for the other party as well to know how to deal with it. So it is, I agree with you, I think all of us have a sort of gut reaction which says the safest course is use your contractual termination right. It's nice and clearly set out in the contract. We don't have to make often a multifactorial decision. Let's use that. But if you put that as your primary case, you may have lost something significant for your client along the way, potentially. Yes,
I mean, that was one of the other points I was going to make, actually, in terms of this, the decision making, if you like, at the time of the notice. It's stating the obvious, but in terms of just stop and think about what the contractual option gives you, either legally or commercially. You know, it may be, for instance, the contractual termination right expressly gives you a right to your money back or whatever, and that may be enough, for instance. Commercially, it may be the market hasn't moved hugely, so you're not talking about a particularly great amount of money. And so I think there's probably, stage one is identifying that there's a decision to be made, and then stage two is identifying whether or not it's worth going down this more complex route of engaging with the issues of notices in the alternative or leading with the repudiatory breach at all. And it's only once you've sort of done that preliminary two-stage analysis you get into the question of, right, well, hang on, how can we best set out our stall to preserve this loss of bargain claim, even though we've got a contractual right that's a little bit easier.
I mean, the good thing is that although these are high pressure decisions, you know, the authorities do establish that the innocent party in the case of a repudiatory breach does have a time to pause and reflect. You know, just taking time to decide whether or not to push the button won't of itself affirm the contract, will it? I mean, perhaps if you left it for years and years, you'd have problems, but you know, taking a bit of time to take advice and think about the consequences and the risks won't of itself be problematic. But once you put ink to paper, as it were, you are committed, aren't you? You're committed down a particular route. And
yes, and I suppose the other issue arising from that is, of course, the longer the period of time you take, the greater the risk that you get an affirmation from somewhere else in the business or something else is going on. It's quite important in these situations to make sure the left hand knows what the right hand's doing, and it's not just the lawyers and the you know, the people at the top who are making the decision, because there'd be nothing worse than having someone on the ground accidentally affirm it, for instance.
Yeah, and there are things that those who draft contracts can do to help their litigation colleagues in terms of being clear about the consequences of a breach when it comes to drafting the contract, and thinking about, are we making this a condition? Are we saying that damages for loss of bargain would be available if it were breached? And there are a variety of ways in which that can be done. Jonathan mentioned earlier the you know, the time hallowed phrase, using times of the essence. That's probably about the one clear way in which you signal that something is a condition, because for almost every other route there is at least one case that will say it didn't work on this occasion. So you have some contracts that say this is a condition of the contract, and there are authorities which say, well, in the context of that particular contract, they didn't mean condition in the sense that we're using it, they meant a condition of sale, a conditional provision of the contract. You can say expressly, if you breach this clause, the other party is entitled to terminate, but that to a certain extent can beg the question as to whether or not loss of bargain damages would flow. You could say, if you breach this contract, the other party is entitled to loss of bargain damages. The difficulty with that is that if in fact the breach is not repudiatory, or if in fact the clause is capable of being breached in a multitude of ways, some of which are trivial, you start to get into the penalties jurisdiction, because you're specifying a measure of damages to be payable, which might not be payable at common law and might be grossly excessive for the particular breach which is committed. So what you do, there's a sort of slight oddity here, which is that the parties are free to specify that a clause is a condition, and that has the consequence of allowing for loss of bargain damages, but they're not entirely free simply to specify that loss of bargain damages are payable. So there's lots of different things to think about in terms of drafting. I guess the best thing is, if you think about it, put everything in. You've got all of these. It's a condition, and time is of the essence, and you're entitled to terminate the breach, and you can get loss of bargain damages. That will probably do it. Shall we take our next poll?
I think so. Let's see where we are.
Thanks. So have you changed your mind about whether contractual rights or repudiatory breach are a safer method of terminating? Let us know. I'm hoping we're not going to get too many saying I'm now hopelessly confused, but it's entirely possible.
You can't affect the poll whilst it's going on.
Oh, really? Breach of election rules, is it? Oh, it's well, only 9% are now hopelessly confused. I'm really sorry that we've done that to you. If you want to get in touch after the seminar, I'm sure we're happy to try and sort out the confusion. There's the majority, or the largest number, say they haven't changed their mind. Still prefer to go for the contractual termination rights, I think. Interesting. Now we've got a few other questions. We can just take these up briefly. First one, I think, probably is for Tiffany and Simon, or perhaps all four of us can have a go at it. Tim Foley said he had a case where a purchaser could not complete because the bank surveyor could not inspect due to COVID. He advised that an unusual action for the return of the deposit, that's section 49 of the Law of Property Act, would succeed. Does the panel agree? Action for return of the deposit. Anybody want to have a go at that? Worth a whirl?
I'd plump for. I think my initial reaction is I would agree. It's a very it's not often litigated, that section, and I can't off the top of my head think that there've been any cases arising as a result of COVID. At least I'm not aware of it. I've not had to look at it, but it seems to me that might be a case where you could have a good chance of getting your deposit back under section 49. Anyone disagree on the panel? Isn't this a question about supervening illegality? So it's impossible to perform your obligation to purchase the land because your surveyor can't inspect due to COVID. Is that?
It depends whether he's prohibited from inspecting by law,
yes,
or prefers not to inspect because
it's risky because they don't want to,
or because the government
exactly. If they're prohibited from doing it by law, but that would only suspend the obligation and not. It doesn't frustrate the contract, it just suspends the obligation to complete, I would have thought. So I'm not sure whether an action for return of the deposit would actually work in that scenario. But
I also don't think that the COVID laws wouldn't legally prevent a surveyor from going in and having a look, because that's work that couldn't be done from home, seems to me. Not sure you can sue the surveyor for not doing the job.
On the other hand, it's not the purchaser's fault that the bank's surveyor has chosen not to go. I'm rather with Simon and with Tim, I have to say. I'd give that a whirl. I think a really interesting one. Could somebody else please find some interesting case, and we'll gladly litigate it for you.
I think Karen Edwards is saying she might have some thoughts on that, but I don't know.
No, I think that's us answering that administratively.
Yes. It's the way it come up on our screens. That's right.
Tim's celebrating, I can see.
Yes. Another one from somebody anonymous. If key milestones are missed, giving a contractual right to terminate, will that right continue until the milestone is met, or is it lost by failure to exercise immediately or within a reasonable time? My gut reaction is depends on the contract, but you wouldn't normally lose your right to terminate because a long stop date has passed. Although you can get into tricky estoppel issues if you treat the contract as being ongoing thereafter, and you might have to give the other party a reasonable period of notice to sort of undo the effect of that estoppel, so that you're telling them, we're going to go back to the contractual provisions now, and I'm going to, and you know, unless something is done, I'm going to treat this contract as being at an end in accordance with the long stop date. Yes,
I suppose the other thought I had on that is, the nearer the terms of the contract get to reflecting sort of common law type analysis, the greater your risk is of affirming it somehow by letting the contract run on as well.
Now, somebody says the judge's comments in the Loader case would seem to suggest COVID would not assist.
No comment.
I think the thing is that each case is going to turn on its own particular facts, and as Jonathan and I are in the Loader case, we're very pleased that the judge agreed with us that COVID did not assist the purchaser in that case. And for those of you who are interested, the trial in the next phase of the Loader case is coming on in the autumn, and we'll be arguing about deposits and part payments and damages and those sorts of things. If you act for a client who receives a notice in the alternative as mentioned, where does that leave them if there's a period to rectify under the contract? Should they take action, or arguably is that suspended pending determination of the repudiatory claim?
Good question. I think the problem with what that does is it shows that the difficult decisions with long-term consequences having to be made quickly apply equally to the recipient of that notice, because you can either say, fine, we accept the contract's ended, either accepting that you're in a repudiatory breach, or it seems to me saying, actually, we accept the contract's ended, but that's because the giver of the notice has renunciated because they're wrongly saying it's a repudiatory breach. So actually we'll counterclaim essentially for repudiatory breach. Or you could say, actually, we want the contract to continue on foot. We don't think it's repudiatory stroke. We don't think they're going to get home on it. So we are going to fix it. I think it would be quite difficult to say that the obligation is somehow suspended, because it's the purported acceptance of the repudiation by the notice giver is either immediately effective or it isn't. The trouble is, you just find out after the event. If it's immediately effective, then it's terminated and there's nothing left to perform. If it isn't, there's the immediate obligation to take action.
It's a variation of all the circumstances that our clients find themselves under when there are alternative rights being relied upon, because the recipient has to make an election, as it were, as to which one they think they're most at risk of going down on and respond to that. Okay, I think we probably ought to wrap up. Thanks ever so much for all the interesting questions. Thanks very much for being here. We've had over 250 people on this webinar, which is absolutely fantastic. Thanks so much. We'd really welcome your feedback. A questionnaire should pop up on your browser as you come out of the seminar. So please do tell us how you found this session, what are the topics we should cover, what we can do better, or to be of more assistance to you. There will be a recording of this session available on the Wilberforce Chambers YouTube channel, so just type Wilberforce Chambers into the search bar. And as I mentioned earlier, it's the first of a series of property talks. The next one is on 20th of May, and Jonathan Davey QC, Ben Faulkner, James McCrath and Francesca Mitchell will be discussing rent in the time of COVID, practical considerations for turbulent times. The focus there is on rent in 1954 Act renewals. So do have a look out for your invitation, which should pop into your inbox over the next few days. Thanks very much to all our speakers, and I wish you all a very good day.